Hello and welcome to the ePathshala course on intellectual property rights. I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. Today we are going to discuss a module on fair use or fair dealing in India. This module will provide an overview of conceptual issues surrounding fair dealing, the rational basis for fair use of fair dealing and including their limitations, the nature of section 52 which talks about fair dealing in India and conceptual issues surrounding fair dealing. Fair dealing in India will look through some cases decided by High Courts and the Supreme Court. We will look into musical works and fair dealing of musical works, what qualifies for review or criticism, whether time factor is essential in case of fair dealing, whether there is a de minimis exception, that is a standalone exception other than fair use, and how do we distinguish between fair use and de minimis, the scope of criticism or review, and fair use or fair dealing of cinematographic films and sound recordings, and post the amendments, what is the scope for fair dealing of remix uses, and we will also discuss the recent DU photocopying, Delhi University photocopying case that is currently ongoing. Finally, we will end up with a brief summary of issues. Now, if you look into issues around fair dealing, we need to discuss a bit on why fair dealing. Primarily, copyright is an instrument to incentivize creators at the same time to create a public domain, vibrant public domain of ideas and expressions. However, since you are giving a property kind of monopoly, there is a deadweight loss on the society, and hence it is a second best solution to the problem of incentives, which means that it would require several balancing factors. Fair use or fair dealing is one such factor. Apart from fair dealing, there is idea expression dichotomy, wherein basically copyright law provides protection only for expressions and not for ideas. However, at times you may also require, in larger public interest, the use of expressions. So, in such cases, fair dealing acts as an exception to infringement. Now, if you look into the underlying basis for copyright and the relationship it shares with fair dealing, it primarily revolves around 4 or 5 factors. The first factor is free speech. One of the important reasons why copyright is being granted is that it is also an expression or engine for free speech. At the same time, it also tries and protects or provides monopoly in the expressions. So, how are you going to balance out the incentives for others to take speech from elsewhere and include it their part of free speech? So, fair use tries and articulates this premise that the underlying basis for free use of expressions from earlier works to a limited extent should be allowed under the law. So, free speech is one of the important factors why fair use exists under so many acts across the world, copyright jurisdictions across the world. Second is the public domain of ideas and expressions. Now, if idea expression dichotomy is considered as the single most important factor which allows others to freely use ideas, but yet use of expressions is important, it is also because by virtue of expressing ideas, there is a vibrant public domain of future ideas that is created, and the public domain that is created by virtue of fair use is equally important. Third is the ease of access. There must not be many structural impediments to access prior works, so fair use creates that kind of formula which offers a wide variety of users to have easier access so that there are no structural impediments. Finally, fourth is affordability. One of the reasons why fair use also exists is that certain uses are treated as free uses, and hence such free uses are on account of the fact that a larger section of the public, for a larger section of the public, these works must be made affordable. And then finally, we have issues concerning authorial integrity, wherein although there are fair uses that is allowed for the larger section of the public, at the same time the way it has to be balanced with authorial integrity and with incentive for creator is paramount in determining fair use from a conceptual perspective. So, the need for fair dealing ultimately boils down to one of the most important principles of public interest, that is access to existing ideas and expressions. Now, the essential core of property right and if you treat copyright as a form of property right, then the right to exclude and the right to alienate should not be interfered with. However, fair use directly interferes with such a right by way of creating what is called as a liability rule. In the liability rule, the value of entitlement, including the right to determine whether someone else should have access to your works without your permission, and the value with reference to what compensation you should derive, is decided by a third party. So in liability rules, market is not determining the value of the entitlement, but a third party is determining. The case of fair use is a case of zero liability rule, wherein no compensation is provided for accessing works. So there can be uses with compensation, which are in the nature of compulsory licenses or statutory licenses, and there are uses without compensation, which is largely fair use. Fair use is thus a zero liability rule. Now, largely fair use across jurisdictions has been based on 4 factors. One is the purpose and the character of use of the work. Second is the nature of the copyrighted work. Third is the substantiality of portion that is used in relation to copyrighted works as a whole, and fourth is the effect on the potential market for or the value of the copyrighted work. So based on these 4 factors, courts usually determine what amounts to fair use. Now if you look into the rational basis for having fair use, there are certain issues that come to that are to be discussed in this context. First one, would there be fair use when there is a possibility of an existing market for a license, and whether existence of mere market for a license deviate from fair use? There are both sides of scholarly discussions around this issue, wherein existence of a market for license need not deviate from fair use, in the sense that mere showing of a market should not mean that there is no fair use. In that case, what would have happened is, because it is now possible to license each and every kind of activity that users would otherwise have it freely under the broader fair use paradigm, it would mean that no such fair use should exist, and that is the reason why existence of a market for license should not be one of the important criteria to assess whether fair use or fair dealing should be provided. Secondly, fair use does not contain use of existing works as they are, but fair use enhances transformative works and transformative uses. So what is important to consider in this context is the balance of incentives. It is not just the original copyright creator or the author who should have a final monopoly on the future works that are created by virtue of the first work, but there should be a balance of incentives for the society to create more transformative works through transformative uses. Now, what is also important in the context of fair use is, fair use vis-a-vis infringement is decided at a point of time when there is a legal contestation. So until then, there is no conclusive proof whether an infringement amounts to fair use, or whether it is actually within the scope general purview of infringement. So in that case, the market power that is conveyed by copyright law by way of an injunction is very strong, and that is why there are certain issues whether injunction should automatically be issued, primarily preliminary injunction should automatically be issued, where a defense of fair use is being taken by the defendant. Furthermore, should the existence of a license, in the sense that bringing down the transaction cost, disentitle us with fair dealing or fair use? This is very important in the context that prior to the internet, the argument was that seeking a license in each and every case would raise the transaction cost, and now if by virtue of the internet it is possible to license on a mass scale and bring down those transaction costs, which means now a potential market for a license exists, then, and by virtue of the bringing down of the transaction cost, fair use should be diluted. Now this particular issue has also been debated for long. Finally, fair use and fair dealing, whether it should be considered as a right or whether it should be considered as a mere defense, is also one of the contentious issues that is being discussed almost in all jurisdictions. And lastly, by virtue of criminalizing copyright, and all copyright jurisdictions are expected to have criminal measures at least where copyright piracy is on a commercial scale. So, in such cases, if criminalization is not just about piracy but extends to infringement in individual cases, will there be a chilling effect on fair use is also an important factor in deciding how far fair use helps actually in generating free speech and works as an engine of expression. Let us look into the nature of section 52. Is section 52 very exhaustive? Of course it is, because there are many, it is probably one of the longest provisions in the Indian Copyright Act, and it has many provisions which exhaustively provides the situations in which individuals can exercise fair use. In Oxford University Press versus Narendra Publishing, it said that section 52, the court said that section 52 only provides a broad hedge and resort must be made to certain principles. Now, what are these certain principles is important. Now, as we have looked into the previous slides, courts across jurisdiction consider some of the 4-factor tests to be the ground principles or the ground norms for determining fair use. So, similarly in the context of Indian fair dealing under section 52, along with the broad heads of section 52, will it be important to consider these principles is a question that needs to be answered. In the case of Oxford University Press versus Narendra Publishing House, the Delhi High Court said that we must resort to such principles. Now, the important question then is, if section 52 provides an exhaustive guide of fair use principles, then what is the further necessity of having section the principles that are usually referred to. Now, if purpose of use is clearly established under section 52, should manner of use be determined by virtue of those principles is an important question. Now, and should we, by virtue of these principles laid down in the Oxford University Press versus Narendra Publishing House, should we be bound by only the 4-factor test, or should we also look into other principles that you might encounter in dealing or in scoping fair use? Now, transformative and non-transformative uses are both fair dealing under the Indian law. In Indian law, you have a wide variety of exceptions which allow you to exactly make a copy in a limited sense to a limited extent, but at the same time it also allows certain transformative uses, especially in case of software, private criticism of review. By virtue of such exceptions, they allow you to make transformative uses of the work. Furthermore, in certain cases, fair use or fair dealing under section 52 allows you to make full copies. For example, section 52 clause Q of the Copyright Act allows reproduction or publication of certain government works, including judicial decisions, and this can be done by reproducing the whole text without any limitation. Now, here if you try and determine along with this section certain broad principles that the court asked us to consider in relation to fair use, you would be unnecessarily or unwarrantedly you will be curtailing fair use. So, the question is whether such additional principles should be considered. Second, for example, where fair use is entirely exempted is in relation to section 52 ZC, which was added by the 2012 amendment, wherein importation of copies of literary or artistic work such as labels, logos and company promotional or explanatory material, which is purely incidental to importation of other goods or products. Now, these shall not be considered as infringement. Now, if you look into the wider scope of this provision, any incidental copying of these promotional material in full is actually allowed under section 52. Whether this should be treated within the general parameters of section 52 is an important question, although section 52 ZC by virtue of the 2012 amendment has introduced it into section 52. Most importantly, what should be considered in the context of section 52 is section 52 is largely to be judged for its consistency with the TRIPS agreement. It is the agreement on trade related aspects of intellectual property rights, which India signed in 1994 and which has come into force since then, and we are expected to be in compliance with article 9(2) and article 13 of the TRIPS agreement. What does Article 13 say? It says that members shall confine limitations or exceptions to exclusive right to certain special cases, A. Second, which do not conflict with the normal exploitation of the work, and third, which do not unreasonably prejudice the legitimate interest of the right holder. The same language is used in section 9.2, article 9.2 of the Berne Convention. However, the word right holder is replaced by the word author in the Berne Convention. This provision came to be tested in one of the WTO dispute settlement panels, that is section 110 of the Fairness in Music Licensing Act of the United States was challenged by European Union. And what this particular provision did in the United States was it allowed certain exceptions called as the home style exception and the business style exception to bars and restaurants and other hotels with certain limited space capacity and which used certain amplifiers to broadcast music. Now, Europeans claim that this kind of exception is so broad that it actually conflicts with the normal exploitation of the right of the copyright holders and hence would violate Article 13 of the TRIPS agreement. The WTO dispute settlement came to a conclusion that the home style exception was indeed limited because it actually defined the nature of establishment vis-a-vis the space and also the amplifiers, but the business style exemption was not, because it went beyond the limited exception that is envisaged in the Article 13. Suffice it is to understand at this moment that the home style exemption was allowed by the panel because of its limited nature and because it would not usually normally exploit with the right of the copyright holder and would not unreasonably prejudice his interest. Now, how is fair dealing of musical works treated in the Indian context? Let's look through some cases now. In Supercassettes Industries versus Hamar Television, the question was whether if the defendant engaged in playing musical albums of the plaintiff's work as part of the news channel, should that be exempted? Now, can the defendant rely, for example, on section 52(1)(a)(2) and section 52(1)(b)(2) of the Act and then claim that these showing of musical albums is part of current reportage or reporting of current events? Now, the question, it was in this case the court held that there must be a quantitative test and it is important, but it is not the only criterion. Quality would be equally important in case of musical work, where even taking of a single note may lead to infringement. Infringement is also possible from the point of view of a lay listener if it formed an essential part of the Copyrighted Act. It was held in this case that section 52 must be confined to purposes limited therein, in the sense that the criticism or review or reportage of the events. And in this case, if you look into the act of defendants, they were using musical albums, and once they showed many of these, irrespective of whether they actually were confined to the purposes mentioned therein, that is criticism of or review or reportage of the current events, they went beyond and showed it as entertainment videos. So, court did not find linkages between the infringing act and the defense provided in section 52 after reviewing of the log table that is usually maintained by the channels, and it went on to say that it amounted to infringement. The court laid down certain principles, certain 13 principles which I call as Super 13, and these principles can guide us in understanding the nature of fair dealing in India under section 52. So, the court said it is not possible, first of all, to define the broader contours of fair dealing. Second, whether it is a question of fact, degree and impression would depend on each and every case. And third, the length of the extract may be important, however, even taking of small extracts may lead to an infringement. Fourth, the right to criticize not only the form, style, etc., but also the underlying doctrine or principles exists as part of fair use. Fifth, what constitutes current events, etc., and in determining these, the courts must generally adopt a liberal approach and must not be restricted by by virtue of certain structural definitions. Sixth, how to judge infringement vis-a-vis fair use must be judged from a reasonable man's perspective, that is a fair minded person or a lay hearer as the court calls it, and these tests would be important in ascertaining infringement vis-a-vis fair use. Quantitative and qualitative must be balanced, both those factors must be balanced. Especially the court said that injunction should not be granted on the ground of confidentiality, since confidentiality is a different ground altogether, especially when it is contrary to public policy. Free speech can be a ground, however liability may be compensatory in such cases. So wherever there is a question of free speech, the court must use the compensatory liability regime rather than the injunctive relief system for allowing fair use of certain works. Furthermore, motive of the use is important whether injunction ought to be granted or not. It means if the motive is way beyond the usual case of commercial nature, then if there is some higher norm that is important for as a matter of public policy, then it must be allowed. Mere commercial use, however, is not unfair, and it not lead to finding of infringement. It means fair dealing of works can also be allowed for commercial purposes. Transformative uses may be fair in certain cases. So these are the broad principles that were laid down in this case. Second is a question of whether time factor is important in fair dealing. In Ram Sampath versus Rajesh Roshan, this is a Mumbai High Court decision of 2009, the issue was whether a 6-second clip of the plaintiff theme, which is a tune being incorporated into the defendant's song, would that lead to an infringement of the work. Court held that it could violate, and hence a temporary injunction was granted. However, the case was mutually settled and the injunction was vacated, but the court laid down the following test. First, it said similarities and dissimilarities between the two works must be assessed. Second, the defendant's work standalone without copying must be assessed. Third, the catchy part in the musical work to which the listener is immediately hooked onto, that must be ascertained. And fourth, even if a small part is copied, the number of times it is appearing in the same song, that is in the defendant's song, must be ascertained, and all these factors combined together must form a holistic perspective of what amounts to fair dealing. So even a 6-second clip can amount to infringement of copyright, provided it's a kind of catchy tune and the defendant uses it repeatedly. But is this a real factor in the sense that there are no exceptions? In ESPN's Star Sports versus Global Broadcast, this is a 2008 Delhi decision, Delhi High Court came to a conclusion that fair dealing is a question of fact, would depend on the circumstances and degree of use in each case. So no standard principle can be enunciated, and in this case they did not come to any conclusion whether time would be a essential factor. In India TV versus Yashraj Films, this is a 2011 Delhi High Court decision. Considering that copyright does not require registration, the level of originality required is definitely low. So whether de minimis exception should be provided, and what is this de minimis exception? That law doesn't care for the trivials, right? So we should not be considering trivial acts of infringement as amounting to infringement, and the court's expensive time and energy should not be wasted in litigating such cases. Now the presence of transaction cost can also be a reason for de minimis. Hence whether it's a standalone exception other than fair use, or whether it's part of fair use, needs to be cleared. Now the court laid down 5 important factors in finding out whether de minimis exception is allowed. It said the size and the type of harm must be considered, what the actual scope of and the type of harm that is caused to the plaintiff's works must be considered. Second, the cost of adjudication, whether it leads to higher transaction cost. Third, the purpose of the violated legal obligation. So what kind of legal obligation was violated and what was the purpose behind this obligation. And fourth, the effect of legal rights on third parties. So including the final factor is the intent of the wrongdoer. So in this case it was held finally that a license which would lead to a a minimum revenue of 10,000 rupees for a 3-second clip that was used, which included something 5 words from the plaintiff's recording of 5 stanzas. That would not amount to an infringement. So in this case the court considered that this is kind of very trivial and this should be excused as a de minimis exception, not even asking whether it should be covered as a fair use at all. Furthermore, what is the scope of criticism of review within section 52(1)(a) clause 2? In Oxford University Press versus Narendra Publishing House, this is the 2008 decision of the Delhi High Court. The question was whether a question bank forming part of plaintiff's mathematics textbook was copied or not. Now the defendant here came with certain guidebooks where they used the questions that were provided in the earlier plaintiff's work, and these guidebooks contained a step-by-step solution to the plaintiff's questions that were raised in the earlier work. Now whether the Defendants Act qualifies for fair dealing was an important question. Apart from whether the question papers could qualify for copyright, the Delhi has already answered in affirmative by that time that question papers do contain copyright. But the next question was whether the Defendants Act of using those questions and coming out with solutions, would that amount to an infringement? The court held that, and it followed what is called as the Campbell-Harpen-Rowe test based on the 4-factor test in the United States. It came to a conclusion that fair dealing is one of degree and impression of the reader, and this test should be generally followed. It also followed the most famous decision of the Supreme Court, the seminal decision of the Supreme Court in R.G. Anand versus Deluxe Films 1978, wherein the court had laid down that the test in such cases should be from the perspective of the reader or the spectator. Now the court in this case held that transformation of work is required, and that is one of the essential characteristics, must not be the same thing as infringing work. Now in this case there was a case of transformation because the defendant was finding solutions to the problems raised by the plaintiff in his work. Fair dealing is important for balancing rights with enriching public pool of ideas and creating a vibrant public domain. The court said that without fair dealing, you would actually impede the creation of public pool of ideas and a vibrant public domain, and that is why balancing of rights is important. Section 52 lays down only the detailed broad heads. We should resort, as we have seen, although they are exhaustive, they merely lay down the broad heads. We should resort to more nuanced principles. Similarities and dissimilarities in the defendant's work may lead to a conclusion of finding of fair dealing and whether the use was transformative or not. What would qualify for a review under section 52(a)(2) is also stated by the court in this case. Review of a mathematical work would mean re-examination of the primary work, and court gave a very broad interpretation to the word review, which meant that you can re-examine the plaintiff's work, and in this case the defendant has actually revisited the questions and assisted students to solve them through a step-by-step solution. So there was no finding of infringement in this case, although the copyright with respect to question papers was valid, but there was no infringement. The question of whether fair dealing extends to cinematographic films and sound recordings was also largely discussed in Super Cassettes versus Chintamani Rao. This is a 2012 decision of the Delhi High Court, but it is of certain limited application now because of the 2012 amendments. In this case, the use of a video or audio clip for the section 52(1)(a) purposes, since it is a derivative work of categories of work mentioned, it was held in this case that the cinematographic and sound recordings have been provided a distinct right in section 13, and it treats them as a separate class of works. And by dropping cinematographic films and sound recordings from section 52(1)(a), the intention was not to create any fair dealing cinema or sound recordings. Now the presence of specific provisions like section 52(1)(i), j, k and za creates an exclusion by implication. Now furthermore, in this case of Civic Chandran versus Amani Amma, the scope of criticism was discussed. In this case, the defendant's play Ningal Are Kamnistaki was infringement, it was alleged that it was infringement of another play of the plaintiff, that is Ningal Ane Kamnistaki, as it had portions of plaintiff's drama. Now it was held in this case that the purpose of work was an important factor in determining fair dealing or for criticism. The purpose of the defendant's drama was not just to reproduce the drama either in whole or in substantial manner, but to convey a certain idea. Now, purpose was also not to imitate the drama by misappropriating it, but the purpose was largely transformative in the sense that it was to write a counter drama which criticized the idea of propagating printist drama and to expose the public that the drama had failed in achieving its real object. Now, post 2012, section 52(1) applies to 1A applies to all works. Now, there is a problem with inherent bias towards the print medium as to the nature of use to imply criticism or review, because what we understand from the jurisprudence is that the criticism or review is largely understood in the earlier context of print and not in the context of new media, and hence films and music sound recordings today are defined by space for creating works heavily relying on prior works which may or may not involve criticism or review. These are primarily kind of amateur works. So, how does section 52 gel well with this new age where amateur works which are kind of mashups and mix-ups of earlier works, and whether they would fit into the criteria of fair use. Now, usually what we would come up with is a balancing formula whether this such criticism or such use in cases of remixes is of the work or with the work, and if it is of the work then it would definitely be allowed in most cases, but if it is with the work then the question of whether it really complies with the broader principles of fair dealing is important. Finally, let us discuss the DU photocopying case. Now, in this case DU professors required some course materials for students along with their prescribed textbooks. Now, these course packs are usually compilations of book chapters and articles. Now, these course packs, they contain portions of different books. Since all books cannot be purchased by the students, what professors usually do is they compile those put together a course pack, and these course packs were made available by Rameshwari photocopiers, which were the agents of the DU. Delhi University had allowed Rameshwari photocopiers within its campus to make photocopies of these course packs that the course supervisors or the professors had formed. Now, these course packs are useful for students in the sense that the price of the course packs was actually the price of regular photocopying. OUP, Cambridge University Press and Francis Tiller has sued the Delhi University and Rameshwari photocopier for infringing copyright. The important question in this context is whether section 52(1)(a) of the Copyright Act, that is private or personal use including research, allows the Delhi University and Rameshwari photocopiers to take this defense of non-infringement. So, does the issue of authorization and character of dealing negate the above exemption, because in this case Rameshwari photocopier was advised and Delhi was authorized and Delhi University was not themselves engaged in the act of photocopying, whether such exception can be allowed. Secondly, the individual students were not engaged in the act of photocopying, but they were purchasing it from photocopiers. So, the agency relationship within section 52(1)(a) is a kind of question in this. Second, does providing multiple copies of the same work negate fair dealing, because you are making multiple copies of the same course packs, whether that would negate fair dealing. Does the use of non-infringing alternatives negate the possibility of fair dealing, because non-infringing alternatives would mean that if these publishers combine together and grant a license, would there be a scope for fair dealing? Fourth, does the nature of course pack compete essentially with the market of copyright holders text or those books or the original works? So, across jurisdictions these issues have been litigated. So, in a Canadian case called Law Society of Upper Canada versus CCH, there was a similar question. We can look into the question case in detail in the module. other question in relation to DU photocopying case is also whether section 52(1) IL, wherein the reproduction of any work by the teacher or pupil in the course of instruction, should that be allowed? Now, in Alberta Education versus Canada Licensing Agency, it is a 2012 decision, the court came to a conclusion that the teacher had no ulterior motive in providing photocopies to their students. Moreover, the instruction cannot be completely segregated from research and private study, because most students require the guidance of teachers to find materials necessary for their research and private study. Third, that the teacher or copier therefore shares a symbiotic relationship with the student or user who is engaging in research or private study, instruction and research in the school context, which is tautological. Hence, in this case the court allowed such an exception. Now, what is important in the Indian context is, what does this course of instruction mean? Should it mean that the act of allowing reproduction of course packs by a university authorized agent, would that fall within the course of instruction or beyond the course of instruction, is an important question. Now, Cambridge University Press versus Baker, this is another US decision which allows 10% of reproduction without a license. Now, if it is 10% in the US, and if such licenses need not be taken for coming out with course packs, should, in the case of India, considering that we have so many access impediments, should this 10% be higher? Some commentators and experts have argued that if it is 10% in the US, it can be anywhere between 20 to 25% probably in India, depending on the specific circumstances. So, the important question now in the DU photocopying context is, should fair dealing consider excess perspectives from the point of view of economic status of the user, that the users generally in public universities cannot afford licensed course packs at higher prices. Second, what then is the use of compulsory licenses? If you already have access built in within fair use, and if you have to look into this issue of fair of course packs from the perspective of fair use purely, then what is the alternative remedy of compulsory license for? Now, this does not mean that fair use cannot be a standalone defense, and thus the question of whether DU's Act amounts to fair use or fair dealing within the meaning of the Act is still contested. We are waiting for the final decision from the court. In summary, before we move on to the summary, I would also like to mention that there have been certain recent amendments in the Indian Copyright Act, particularly the 2012 amendment relating to digital rights management. Now, here the legislature has gone ahead to provide digital rights, that is in the context of internet, wherein technology protection measures are protected in the sense that any breaking of such measures for accessing works which do not fall into the regular fair use criteria shall be considered as an infringement. Finally, in summary, what we can say is that we have discussed the fair dealing and fair use from a conceptual perspective, including the rationale behind fair use and their limitations. We discussed the nature of section 52, whether there is an exhaustive, whether transformative uses are allowed, whether copying in certain cases like importation, and in cases of reproduction of legislative works or court precedents, which is much more than regular fair use, should that be allowed within fair use. We have discussed it from a conceptual perspective. We have also looked into several cases decided by the Indian courts in the context of musical works, in the context of what qualifies for review, what qualifies for criticism, whether time factor is essential, whether de minimis exception is a standalone exception and whether it goes beyond the fair use, whether cinematographic recordings and sound recordings, should that be within the scope of fair use, and we raised certain issues prior to the 2012 amendment. We have also looked into the contemporary controversy involving the Delhi University in relation to infringement via the course packs. So, with this we conclude this module on fair dealing in India. Thank you very much.